A very good afternoon to you, Lisiba, and thank you for coming in. So what was it about these agreements and the interest rates in particular that was so problematic?
Good afternoon. The real problem was the higher interest rates on a loan that we call a short-term loan. And this is a loan which its size, it's up to 8,000 rand, and the capital value of the loan is 8,000 rand payable within 6 months. The interest rate, if you were to annualize it, was 60% per annum, which translates to 5% per month. And what we found was it was resulting in many consumers being trapped in a debt spiral.
And in this legal battle that's been going on for at least 2 years now, it was the MFSA that was fighting you. In fact, they won the first round in court, and you eventually took it on appeal, and you've now had this success. What was their argument against your position?
Their main argument was that there were no proper consultations, and the reduction of the interest rate will drive micro-lenders out of business. We obviously didn't agree with these arguments because we felt that the level at which we set the interest rates was appropriate because it was at 38% per annum, which is still the highest rate of interest across all credit products.
This case, Lisiba, feeds into the problem of reckless lending, especially among micro-lenders, doesn't it? And I'm wondering why it is so many years later, there still hasn't been an ability to sort of grab hold of the industry so that it plays by the books as far as what the bigger lenders are forced to do.
Yes, there are some aspects relating to reckless lending, which we find not only amongst micro-lenders, but many other credit providers. As you recall, about 2 years ago, we introduced strict affordability assessment regulations, which require consumers to produce written proof of income when they apply for credit. Unfortunately, some parts of those regulations were declared invalid by the Western Cape High Court.
Which means what then for the average person who is taking out a loan with a microlender?
What it means currently is there is no requirement in the law, for example, for a consumer who is formally employed to produce a pay slip when they apply for a loan. And we think that judgment is very bad in that sense.
Are you challenging that judgment as well?
Unfortunately, the TTI decided not to appeal the judgment, but we're doing some work which will ultimately result in that judgment being challenged.
Let's go back to the judgment which you have challenged and successfully done so against the MFSA about these interest rates from microlenders. These will be coming down. Does it apply retrospectively, or will it be to the benefit of people who get loans going forward?
The regulations came into force in May 2016, which means from that time you were supposed to pay 3% interest on a second loan in a calendar year. And when they won the case in the High Court, we, within a week, lodged an appeal. And that suspended that judgment, which means throughout this period, these regulations were in force. And what it means is any short-term loan that you receive from 2016, and obviously because many of them will be up to 6 months, and the majority of the loans will be between 1 and 3 months, people would have been paying 3% interest on the second loans.
What do we do then in cases, Lisiba, where you've got people who say, I did go to a microlender, it's not one of the bigger ones, and they still charged me this higher interest rate? Is there any place they can go for recourse?
They can complain to the NCR, and we will investigate the complaint. And if we find evidence that they were charged higher interest rates, we can order the microlender to refund them.
Lisiba Mashapa from the National Credit Regulator, thank you so much for your time.